Hi, I'm Jason T. Brown, head of the whistleblower law firm Brown LLC. Every day we receive questions from individuals who are thinking about blowing the whistle. And if you're one of them, please feel free to email our office about your question, whether you want to speak with an attorney for a free confidential consultation, or alternatively, whether you want me to speak about something in a video. Happy to do a video on whatever subject you, the listener, wants to hear about. For today, I'm going to answer some questions about the False Claims Act. The False Claims Act is a very successful statute that was enacted in the time of Abraham Lincoln, therefore known as the Lincoln Law at times. And what it does is allows private individuals to bring cases on behalf of the government as well as oneself. And what I mean by that is if the federal government / taxpayers are defrauded in some manner, an individual who's an insider and knows about that fraud can confidentially file a case under seal. Defendant doesn't know about it. It's confidential, sealed with the court. The only people that know about it when you file it are you, your lawyers, and the Department of Justice and the court, not the defendant. And what that lawsuit's saying is some defendant or an entity has defrauded the federal government and taxpayers out of money. If the case succeeds, you as the False Claims Act whistleblower are entitled to up to 30% of whatever the government recovers. And in recent years, in aggregate, that's amounted to over $1 billion for whistleblowers. Our firm, Brown LLC, is pretty prominent in the space. When I say prominent, whistleblowers like to stay secretive, and we're kind of under the radar, but ranked by Lex Machina as who's the second most prolific firm in the country. Brown LLC came in second in the country over the last 5 to 10 years. A couple other questions people ask about the False Claims Act is, what does Qui-Tam mean? And Qui-Tam is Qui-Tam ex regis, and a whole fancy Latin phrase, and it means he who brings a case on behalf of himself as well as the king. And in the False Claims Act world, the individual who brings the case is bringing the case on behalf of themselves and the government. The government is proxy for the taxpayers. Since they're a plaintiff and they're not only representing their own interests, they're relating the story of the government through their lawsuit, they're known as a relator also in this type of term of art. People want to know what role, if any, will they have after their case gets filed. Well, let me take a step back and talk about what role they have before it gets filed. And before it gets filed, you will need to work with a False Claims Act law firm. You cannot file a case like this pro se. Pro se means without an attorney. Generally, because corporations in federal dogma or law require a legal representative, the government is really the party of interest, and you need to have a lawyer to vicariously help represent the relator and present it to the government. What you will do with your whistleblower law firm is go over the facts. It's the function of the Qui-Tam law firm to understand the law to find out whether it's actionable or not, but it's generally actionable if you know of information of the federal government being defrauded. That typically occurs in Medicare fraud, Medicaid fraud, TRICARE fraud, defense contractor fraud, pharmaceutical fraud, and in recent years, PPP loan fraud and customs fraud. Those types of frauds, if you know about those frauds going on, you may potentially qualify as a False Claims Act whistleblower. And before it's filed, you're going to go over with your Qui-Tam law firm the facts, because ultimately you're the one who's swearing about the authenticity and accuracy of the factual dispute. As lawyers, we want to believe you. We try to verify the story and look for independent corroboration, but ultimately the facts rely on the whistleblower telling the truth. So we will go over with the whistleblower, make sure that the information sounds accurate and truthful. And after we do that, we'll confirm with the whistleblower in writing that everything that they're saying is 100% truthful and accurate to the best of their knowledge. And then it gets into court. After it gets into court, it's confidential under seal. You do not serve the defendant. Rookie mistake. You make sure that you file it properly so the court seals it, because sometimes hiccups happen with the government. Don't be so surprised. It just occurs. So you do everything you can to make sure that the court system knows that it doesn't go onto the public docket. It stays private. Once there's a docket number, your lawyers will also serve that on the Department of Justice and the local United States Attorney's Office. They may serve it on different states if states are parties of interest, and they work on something called a disclosure statement. A lawsuit under the False Claims Act is in legalese to some extent. It has all these legal jargon, and it reads like a lawsuit does, which may be exciting to lawyers, but not really appetizing and digestible for normal human beings. A disclosure statement puts in more of a paragraph form, a narrative about what the facts are about the case, so somebody can read. And when I say that's somebody's the Department of Justice. That doesn't get filed with the court. That's just confidentially served upon the Department of Justice, so they can read certain things like, what is your plain English explanation for the case? Who is likely to corroborate what you're telling the government? What other witnesses are out there that might have great information but may not be so helpful, and why? How much potential damages are there? It may surprise you, in lawsuits, you don't necessarily need to state the amount of damages. You may for jurisdictional purposes, but generally you don't. You may put in the disclosure statement what the scope of damages are, more about the defendants than you want to put in the complaint. If there's some evanescent evidence that's likely to disappear unless the government acts on it quickly. Is there a likelihood of patient harm? I mean, that should be in the complaint as well, but if, for example, it's a Medicare fraud where doctors are performing eye surgery for no other reason but for billing Medicare or Medicaid. Horrific allegations. Has it happened before? Yes. Will it happen again? Probably. Explain to the federal government why your case has to be triaged through the disclosure statement. After the disclosure statement goes out, your lawyer and law firm will interface with the Department of Justice. While interfacing with the Department of Justice, the DOJ will then decide whether they want to interview you as the whistleblower. Most likely, they will want to, if it seems credible, if there's not certain seedy things in somebody's past, and I'll get to that in a second. Because if they have a belief that what you're saying is accurate and there's a fraud going on, they're going to want to eventually tackle that fraud. And they're going to understand many different things from you and how you hold up as a witness. And that's really the function of your firm, to prepare you for what is an informal, and I'll say informal, nobody's recording it, but somebody is taking notes from the federal government, an interview with you as the whistleblower from the Department of Justice and other interested entities who know about it under seal. Defendant's not there. Again, it's secretive. And they will talk to you as the whistleblower. Your law firm will help prepare you for that interview, and that's why it's important to have a very experienced law firm prep you so you understand what to expect on that given day, and also if there's any curveballs on that day, to be able to deal with it. Now, sometimes the Department of Justice is not going to want to talk to you. If unfortunately you have a highly checkered past, what I mean by that is if you have some criminal background that they may find is egregious for a certain reason, they may want your information but want to keep you at arm's length so they're not seen to be technically in bed with you, although at the end of the day, your case can still succeed. You need to go over that with your attorney before you file. It's bad for that surprise to happen at the relator interview, or strike that. Maybe there's no relator interview as a result of something you've done in your past. And these are things you need to weigh. Another question people ask, what happens after that? Then happens the long wait. When I say happens, maybe from your perspective, nothing happens. But in reality, lots of things are happening. After the Qui-Tam case is filed, the government has different components. False Claims Act is civil. It's looking for civil remedies, the recovery of money on behalf of the taxpayers who have been defrauded. Calls for triple damages, calls for other penalties, calls for attorney fees on top of that, prohibits retaliation. So that's all the civil components. But there's also potentially a criminal component of it. If you're scamming the federal government, you're scamming the taxpayers, depending upon how the government perceives that scam, you may have to wait a lot longer because they may be looking at the defendants for criminal consequences. One of the big no-nos in Medicare fraud, Medicaid fraud, defense contractor space, pharmaceutical litigation under the False Claims Act is when there's kickbacks, when people pay to play, when there's an inducement given in order to prescribe a medicine or receive a Medicare patient. And when the federal government hears about something along those lines, for example, the criminal AUSA, criminal assistant United States attorney, will start to look into the matter. During your relator interview, there may be people, the interview when the government's talking to you confidentially and nobody else knows. There may be people from the criminal side of the house as well as the civil side. Or they may segregate it. Criminal may not want to talk to you for one reason or another. They want the investigation to go on an independent track, independent from your testimony at that point, although they'll want to use you down the line. So there is a long period of what appears to be a wait going on while the federal government's doing its investigation. It can be doing just the civil investigation about the conduct you allege from an economic standpoint, but that civil investigation may be put on the back burner because the criminal investigation's at the forefront of the government's mind. So it can go at a really slow, glacial pace. But at the end of the day, the government is going to make a decision. Number one, are there going to be criminal charges? If not, number two, is the government going to intervene for the civil charges, for the civil complaint? If it intervenes, that means the government is taking the lead in the litigation. Oftentimes, when the government intervenes, the case is settled confidentially while under seal, but it does become public at some point. If the government does not intervene, then it goes on many different tracks and trajectories. Government could say, I don't want to handle the case at the helm, but you have private attorney. This is a decent case. We don't have the resources. You go ahead and litigate it. In which case, you should still have a conversation with your attorney about why the government didn't take the case, and is it worth prosecuting at the end of the day? Is it worth privately prosecuting? Because you could litigate as much as you want to, but at the end of the day, you still need to turn to the government for permission to resolve that case. And the government will shadow you with an assistant United States attorney. Now, they may also tell you, the government, we're not intervening and we want you to dismiss the case. Something has to do with the Granston memo codified by the Supreme Court, which is if the government's truly the party in interest and they tell you you have to dismiss the case, you pretty much have to dismiss the case. You can't proceed with the litigation. Now, when the government intervenes, there's some interesting facts about that. When the government intervenes, you can only get up to 25% of the recovery. If the government does not intervene, you can get up to 30% of the recovery as the whistleblower or the insider. So you might be thinking, that's terrific. Hopefully the government doesn't intervene in my case. Well, yes and no. Yes, you get a larger percentage, but generally, even though you get a larger percentage, from the law of averages, the average settlement with the government intervening is $13 million. Non-interventions just shy of $3 million. So you get a bigger piece of a smaller pie. Generally, if the law of averages hold, you're better off if the government intervenes and tries to settle the case while it's under seal. Again, even if settled under seal, it will become public at some point. You can go over with your attorney what your options are to try to keep you cloaked in anonymity. It's not going to happen at the end of the day, most likely. You can John Doe it, you can file it through a dummy corporation, but ultimately if you're receiving money, the defendant's going to probably want your signature on some sort of settlement agreement to try to figure out who the heck you are. And if you're going to litigate it without an intervention, and almost certainly the identity of the whistleblower will be disclosed. Another question that people commonly ask in False Claims Act litigation is, will my case go to trial? Well, in short, it's anybody's guess, but in even shorter, the odds are strongly against it. 99% of cases plus, and I mean more than 99%, get resolved before they go to trial, one way or another. I just told you about a couple ways it could resolve before trial. Via settlement, via the government telling you you have to dismiss the matter. But another way it can get resolved before trial is it unfortunate if the judge throws out the case. Government doesn't get involved in the case. Generally, the defendant does not answer the complaint. Okay, after it's been confidentially under seal for several years, government doesn't intervene, it becomes unsealed. It becomes public. You have to serve the defendant with a copy of the complaint. After you serve the defendant with a copy of the complaint, they can answer the complaint or they can move to dismiss, which is generally what they do. At that juncture, the court may dismiss the case, whether you like it or not. Or you can conduct discovery, meaning you overcome the motion to dismiss, or they answer the complaint. And after that, you exchange information. There's something called interrogatories, depositions. It starts taking the normal course of litigation that you're accustomed to seeing on television shows. Maybe that's a little too theatrical, but the normal course of a lawsuit starts taking. And then after the discovery is done, after people are deposed, people go into a room, the opposing side gets to ask some questions under the federal rules for up to 7 hours. You depose their witnesses to find out what they would say at trial. You get deposed, and your attorney will prepare you for that, so they understand what you would testify to if it goes to trial. Then after everything's cleared, each side can move for something called summary judgment, which means even if everything the other side's saying is 100% accurate, the other side still loses. So at that point, the court could, number one, throw out the case and say you're wrong in summary judgment, saying, yeah, even though you're right about everything that you said, you still lose as a matter of law. It's not something cognizable under the law, not something that the False Claims Act was meant to address. Or maybe the court says the opposite. Your team moves, the plaintiff side moves for summary judgment. They say, yeah, we accept everything the defendant said. You defrauded the government. There's just no defense. There's nothing to try with the jury. And you win at that point, and it becomes a damages case. And then from summary judgment to the trial date, there's still a lot of acres of litigation, but a lot of things settle at that juncture too. If the court says, listen, I can't figure out who's telling the truth, that's not my function, that's a jury's function. On certain days, a jury may say plaintiffs win, certain days, jury may think defense wins. Well, a lot of times that's fertile for settlement because each side then has cognizable risk. And you start to size things up. The cost of litigation, the potential recovery versus the potential of succeeding. So for example, and this you would go over with your attorney as well, in any lawsuit, if there's $100 million worth of damages in the case, but you only have 1% chance of winning, well then it's like poker. The pot odds about what the value of that case isn't $100 million, it's $1 million. And you need to go over those types of things with your lawyer. So in short, or now it's been long, like lawyers like to talk a lot, will your case go to trial? Most likely not, but Albert Einstein used to say, in order to have peace, you must prepare for war. In order for your case to potentially have its maximum value, your law firm, your Qui-Tam law firm, needs to work that case up as if it's going to trial. You can't blank. You have to expect that it is going to trial, and at the end of the day, be ready to try that case, maybe even pick a jury, Maybe you settle after you pick a jury. Maybe you don't settle at all and the jury's got to come back with the verdict. But that's probably one of the most remote possibilities, but it happens from time to time. I thank everybody for their questions about the False Claims Act. Like I indicated at the beginning, we really like to hear from people. I don't just like to shoot videos to see myself and my bad new haircut. What I like to do is hear from everybody out there in the audience. If you have something that's a burning question, you're welcome to contact our firm directly if you want a free confidential consultation, or alternatively, write to our firm and say, hey Jason, here's a topic that's a burning topic of my mind. Maybe you're studying for law school. Maybe you happen to be somebody who doesn't want to confront us at this point because you're really well secreted in a company and you just want to hear a video about upcoding or kickbacks in more detail, or some other part of whistleblowing, like the SEC whistleblower statute. Whatever it is, write us. I'd love to talk to you about it and talk to the world about it. Thank you very much.